this Henry, we were talking before we got you on the screen, and you didn't see a talk this morning, is that correct?
Correct.
Okay. So, my understanding is that, let me go back up this, Captain Hammer's very report of this Henry, and then, very happy to have a mistake. Alright, so, this Henry is charged with burglary and theft, and, second degree felony and a third, fifth degree felony. And the court was informed that there is a plea agreement that reached, and, I'm going to show that, here on the screen here, this, Henry, so that you can see it, and everybody can see it. And let's see here, make sure I get that correct. Okay. Now you see that plea form there, Miss Henry?
Yeah.
Alright, and that's an indication that for McKenna plea of guilty, and it says it's going to be attempted burglary. And is that, you recognize that document?
Yeah. I did.
I'm going to scroll down to page 3, and right there it is. It says, on the screen, you see the sentence that says, I enter this plea voluntarily, believe that signature dependent, looks like Elena Henry.
I can't actually see the signature, but you're on inside.
Okay. Alright. And so, did Miss Actor discuss that with you and say everything to you, and go over everything with you?
Yes, we did.
And you fully understand the plea agreement that you signed?
Yes, I do.
And you indicate early, do you feel that you've been pressured or forced in any way into doing this?
No.
You've had enough time to fully consider the matter of where you signed this document as well?
Yeah.
Okay. And are you entering into this agreement to plead guilty voluntarily?
Yes.
Alright. I'll go back up to page 1 then. And it says,
Judge,
yes.
we can't see the document, but we can see your inbox.
Okay, well, okay, I'm sorry, let me, go back up here, let me, get the wrong thing, let's make sure. Okay, there we go, let's see. Oh, okay, yeah, how about that?
Yeah, I didn't see it. Yeah, that's good.
Okay, I'm sorry, alright. So, Miss Henry, I'm sorry, I apologize, I thought I, clicked on, I had it up earlier when we were doing the test, and then when we, when I turned it off, I thought it would call back to that, oh, wait here. Alright, so, alright, page 3 there, there's the signature, you see it now?
Yes.
Okay, alright. So, going up to page 1, it says that you are going to withdraw your not guilty plea to the offense of attempted burglary. Now, currently you're charged with burglary, which is a second-degree felony, and it actually carries a sentence of between 2 and 8 years as a minimum, and up to an additional 50% of whatever sentence the judge proposes. So it was a maximum of 8 years imposed, and it could be as much as 12, depending on what the Department of Corrections determines that you should serve. Now, under the law, attempt is a crime, and what an attempt is, in this case, is that it means that you engage in conduct which, if successful, would have constituted or resulted in the offense of burglary. And what that does is, under the law, attempt reduces the charge by 1 degree. So it goes from a second-degree felony to a third-degree felony, and that means that instead of a 2 to 8 year sentence with a possible additional 50%, the maximum prison term would be 36 months, as is shown there on the screen. Now, if a prison term is imposed, there are different increments between 9 and 36 months that the court has to pick from. And then there's a fine available of up to $10,000. You understand that?
Yes, sir.
All right, and are you facing any felony charges in any other jurisdiction?
No, sir. I've never had any felony charges anywhere.
So you're not on probation, community control, parole, or post-release control for a felony?
No.
Okay. Now, under the law, in this case, if you are sentenced to prison and serve the prison term imposed by the court, upon completion of that prison term, it is mandatory that you be put under post-release control supervision for a period of at least 1 year as a minimum, up to 3 years as a maximum, as determined by the parole authority. So it is required to be at least a year, and they could decide it should be 3 years. What that means is you'd be supervised by a parole officer on the terms that the parole authority says, because the court has no involvement with that. And if during the time you're being supervised, they determine that you have failed to comply, then they could return you to prison, even though you served the entire term set by the court, for an additional period of up to 9 months for one violation. But there's a cap or limit of half of whatever prison term the court imposed for all violations. But if you commit a new felony while you're under post-release controlled supervision, then in addition to whatever sentence the judge in the new case could impose, the judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of 1 year, whatever time was left on that post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case leading after. Do you understand that?
Yes, sir.
Under the law, I'm not required to sentence you to prison for this offense. And so that community control there, that means that you would be, instead of being sentenced, prison would be put under supervision of a probation officer at a term set by the court for a period of up to 5 years. Now, if during that period of time, the defendant or the probation department felt that you were not compliant, they would have to file a written notice that with the court, serve a copy on you. There would be a hearing. You would be entitled to have counsel. And if the outcome of that hearing was that you failed to comply, then at that time the court would revoke your community control and then sentence you to the potentially to up to 36 months in prison and fine you $10,000. Do you understand that?
Yes, sir.
Right now, the charge in the indictment, as amended, would read, well, let me read it as it currently stands. Currently it says in count 1 that on or about August 8, 2021 in Highland County, Ohio, Robert L. Woodruff and you did by force, stealth, or deception knowingly trespass an occupied structure or separately secured or separately occupied portion of an occupied structure with purpose to commit in the habitation of criminal offense. So that's the charge of burglary, the second-degree felony. Now the amendment would read that on or about August 8, 2021, Highland County, Ohio, that Robert L. Woodruff and you did engage in conduct, purposely and or knowingly engage in conduct which, if successful, would have constituted or resulted in the commission of that offense I just mentioned. So that's what reduces it by 1 degree to an F3. Now, do you understand the charge and what the state's saying you did, when, where, and how they let you did it?
Yes.
And you understand the potential penalty for that offense?
Yes, sir.
Now, we discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you could try to raise at trial, and a possible outcome of the trial with your attorney.
Yes, I have.
And are you satisfied with your advice and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
No, sir.
Now, has anyone threatened you to get you to plead guilty here today?
No, sir.
Now, there on page 2 that we're looking at on the screen, there's some bold print underlined, and there's part of it that's been stricken out, and there's also some additional handwritten language there. So I'll read it as I think it is supposed to read, and it reads as follows. Defendant shall enter plead guilty to count 1 as amended. State will dismiss count 2. Defendant shall pay full restitution and cooperate fully against co-defendant. State and defense will argue sentence. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir, they did not.
Now, under the law, Ms. Henry, the matter of sentence is up to the judge, not to the parties. And so even though, well, there actually isn't any particular recommendation. So no one has promised you any particular sentence if you plead guilty here today.
Correct.
All right. And do you hold any license or certification from the state of Ohio for any type of profession or occupation?
No, sir.
All right, you have certain constitutional rights, you must understand, before I can accept your guilty plea. First, you have a right to have counsel, and I appointed Ms. Hampton to represent you. Now, she was not appointed simply to work the case out, but to provide any defense that might be available to you under the law that you wish her to provide. So, if you decide you don't want to do this, she'll still defend you, including in trial, if that's what you want. Do you understand that?
Yes, sir.
Right, now under the Constitution, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that are residing in Hyde County who are summoned for jury duty under trial. After those 12 are selected, they will hear the evidence and be instructed on the law, and then that jury would have to decide by unanimous verdict, being all 12 would have to agree, to whether or not the state proved their guilt by proof beyond a reasonable doubt. Do you understand that?
Yes, sir.
The Constitution, you also have a right, if you wish, to waive or give up in writing your right to have a jury trial. Waive means to give up, and then that means you would have a court trial. And then in that case, the judge would be the one who would hear the evidence instead of a jury. The judge would apply the law and decide whether or not the state proved your guilt by proof beyond a reasonable doubt. You understand that?
Yes, sir.
Under the Constitution, you have a right to confront the witnesses against you and cross-examine them through your attorney. What that means is the witnesses against you have to come into court and testify in front of you and your attorney and anyone else that's present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
And under the Constitution, Ms. Henry, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're uncertain are going to come in voluntarily, you request the court issues a court order that's a subpoena that force those witnesses to come to court to be available to testify for one of the two, even though they don't want to be here, which is the same way the state's witnesses are forced to come to court. Do you understand that?
Yes, sir.
Right, now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence against yourself at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't. You make that decision. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one can even comment about it, except in one situation. That is, if there's a jury trial and you do not testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
All right, now under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. Okay, I did something that I don't know what I did here, but I took that off the screen. So I'm going to try to figure that back out here. Okay, it says on pause that. I'm trying to unpause my screen, Sherry. I don't know how I paused it.
We can still see it.
Can you still see it?
Yes.
Oh, okay. All right, it says on my screen that it's paused. Okay, good. So I'll go on then. I can find it here. Sure, everything was coming in. Okay, I tell you what's happened is everybody can see it but me. Okay, so I'm going to stop share and reshare. There we go. I don't know what I did, but there we go. Now I've got it back. I can see it. Can you guys see it okay?
Yes.
Yeah. All right. Now, back to where I was. So, under the law, you have a privilege against self-incrimination, which means you can't be forced to give evidence at any time in the case, including trial. And as I said, no one is allowed to comment about it or talk about it in any way except one situation. That is, if there's a jury trial, you don't testify. The judge does instruct the jury that because that's your right, they cannot consider it for any purpose. But other than that, you can never be required to testify. The prosecutor can't make it, the judge can't make it. You understand that?
Yes.
Under the Constitution, you have a right or a presumption of innocence, which means that the state is required to prove your burden, to prove you're guilty. You're not required to prove you're not guilty because the burden of proof is upon the state. And so in a trial, if you're not even required to present any evidence in your defense, you may, but you're not required to. Whether you do or not, burden of proof will remain upon the state to prove your guilt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Right, now originally entered a plea of not guilty. The not guilty plea denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all those rights that I just described. Now, if you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea will admit the allegations in the indictment, admit that they're a crime, and admit that you're the one that committed that offense. And that plea waives, gives up all the rights that I just described for you today, except the right to have an attorney, because you always have a right to have an attorney no matter what you plead. But with that exception, your plea of guilty, waives, gives up the right to have a jury or court trial, waives, gives up the right to confront the witnesses against you and cross-examine for your attorney, waives, gives up your right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. It waives, gives up your privilege against self-incrimination, because if you say you're guilty, that's what you find you guilty. And finally, it waives, gives up your presumption of innocence, because if you say you're guilty, then the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. Do you understand all of that?
Yes, sir.
Also, a plea of guilty waives or gives up your right to file an appeal on any alleged violation of your rights you feel may have occurred up to this point. Now, if you are sentenced to the maximum sentence, or under other certain limited circumstances, you can file an appeal. That would have to be filed within 30 days if your sentence and entry are being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Ms. Henry?
Yes, sir.
All right, now, do you have any questions about the charge or the possible penalties?
I don't believe so at this time, Your Honor.
You understand it?
I believe I do.
Have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
You have any questions about the constitutional rights I've explained?
No, sir, I do not.
You understand those?
Yes, sir.
Have any questions about the plea of guilty, what it means, and what will happen if you enter that plea here today?
No, sir, I do not.
You understand?
Yes, I do.
Do you have anything you'd like to speak with your attorney about before we go any further?
I believe we took care of all that this morning prior to court.
All right. Have any questions about anything that I've explained to you here this morning?
No, sir.
All right, then is it your decision, Ms. Henry, to withdraw your not guilty plea and plead guilty to the amended charge in count 1 of attempted burglary, a third-degree felony? And as to the charge, as amended, which would read that on or about August 8, 2021 in Miami County, Robert L. Woodruff in Ohio, Robert L. Woodruff and you did engage purposely and or knowingly engage in conduct which, if successful, would have constituted or resulted in the offense by force, stealth, deception, knowingly trespassing in an occupied structure or any separately secured or separately occupied portion of an occupied structure with purpose to commit the habitation of criminal offense, violation of section 2911.12A2 of the Ohio Revised Code, charge of attempted burglary, a third-degree felony carrying possible prison term between 9 and 36 months, a fine of up to $10,000. How do you plead?
Guilty.
All right. The court finds that on this day in open court, defendant was advised of all of her constitutional rights, made a knowing, intelligent, voluntary waiver of the same. Pursuant to Rule 11, the pleas accept the order filed. Defendant is found guilty of the amended charge of attempted burglary as set forth in count 1 and it's amended. Count 2 is dismissed. The court will order that the matter be referred to the probation department for a pre-sentence investigation. I think Mr. Arjim is in this call. And that will also include an assessment for substance use disorder and mental health assessment. Hearing or sentencing will be on January the 5th at 9 a.m. And so you need, Mr. Arjim, you want her to call you as soon as she gets done here?
Yes, Your Honor.
All right. So
Yeah, you call her come in.
Yeah, you can come in. Plan on that.
all right.
I'm in municipal court right now, so.
Okay. Well, as soon as you get done there, then you go up and he'll get the appointment set up for you to do your pre-sentence interview. All right. Is there anything further, counsel?
No, Your Honor.
All right. Thank you.
Thank you.
You may log off, Ms. Henry. Okay, I believe our next case is well, somewhere I've stuck my calendar somewhere else. So anyway, you're Michael Orr, period there from the jail.
Yes, sir.
All right. And let's Let's see, who's your attorney, Mr. Orr? Oh, that's Wagner. Okay, I didn't see.
No,
Okay, this is case number 21 CR 179, State of Ohio versus Michael T. Orr. This hearing is being conducted by Zoom. Prosecuting attorney Collins is representing the state. The defense is represented by Jacob Wagner. And you are Michael Orr appearing there from jail?
Yeah.
All right. This hearing is being conducted by Zoom. It's a first pretrial. The defendant is charged along with John Richards with breaking and entering and theft, both 5th degree felonies. Let's see. Look for an arraignment entry here. Actually, I think
November 2nd, sir. Journalized.
when?
I have a journalized copy on November 2nd.
All right, here it is. Okay, final pretrial set on the 15th December, and the trial date is January 11th. All right. Now, I see that the state has provided a discovery, and let's see, is there bill particulars as well? So yes. Okay. All right. Now, have you provided discovery yet, Mr. Wagner?
I'm not, sir. I'll get it done today.
Okay. Well, as long as no final pretrial, you anticipate any pretrial motions?
Not at this time, sir.
Okay. Has there been a written plea offer provided?
Yes. I related to my client, Your Honor.
All right, great. All right. Okay, then are there any other matters that need to come before the court at this time?
No, sir.
No, Your Honor.
All right. Okay, we'll see you on the 15th then, Mr. Orr. Thank you. All right, and I think we have Samaria Jones there.
Your Honor, she is bonded out.
Yeah, she's on the line here.
Can I use the jail for my Zoom, Your Honor, running to a separate?
No, I can, we can Zoom you. I'm sorry, we can, oh, here we go, I'm trying to figure that. All right, Miss Jones, would you unmute yourself there, please?
Yes.
All right, this is case number 21 CR 161, State of Ohio versus Samaria Elena Jones. And you are Samaria Elena Jones, appearing on the screen marked Samaria.
Yes.
All right. The defense attorney is Jacob Wagner. He's appearing from the jail hearing room. The prosecutor is Elena Collins, representing the state. Defendant is charged with 3 counts of aggravated trafficking of methamphetamine and 3 counts of aggravated possession of methamphetamine. This is a first pretrial. Final pretrial is set for December 15. We have a trial set for January 27th. Now, did you want to talk to her, Mr. Wagner?
To my client's credit, she's been very good. She called me the moment she found it out. We spoke yesterday, we spoke today.
Okay.
So, if I may, sir, I'm going to maybe, I would say, slow the case down a little with the document back because she's being held in detention. Got the discovery. It's pretty thick. We're going to try to upload it and scan it to her. I'm afraid the files will be too large. I believe I need to get a USB port to the prosecutor's office. I spoke to Catherine yesterday. I'm still kind of getting everything together, Your Honor, but I anticipate filing a motion to continue the pretrial after she's out, Your Honor.
All right. Just out of curiosity, can you compress those digital files so they can be sent more easily, and then once you get them, you can restore them?
Not smart enough to know that. My secretary does.
I'm not either. I just heard about watching the news this morning about the Kenosha case where they said the problem was that the defense got the video in a compressed version, and then they found out that they didn't know that, and they said it was different by looking at it without it being compressed, and it improved the quality. they were alleging that was a mistrial, but my understanding it was better, so I assume it, and they showed the jury to do it. So that's just why I asked to know, because I don't know, I know when I send photos, sometimes it asks me if I want to send them actual or compressive, but I will send them actual because I don't know what it does to them. But anyway, it's just curiosity. Okay, well, if you need to do that, that's fine. You can file your motion and we'll, take a look at it then.
Yes, sir.
All right, anything further from council at this point?
No, sir.
Have a mistake.
Okay. All right, thanks very much. And I believe that's the end of the hearings for today, or for this morning, and we're gonna have some this afternoon, so.
If I may, sir.
Yes, go ahead.
Your Honor, I was informed from my office that Mr. Bach was picked up late last night.
Yes.
I believe he may be held in cages for not appearing for his mental health eval.
That is correct. He'll be there until they see him. Once they see him, he's released. But he had 2 appointments he didn't show for. And, of course, he had arguable excuses, but, they refused to make another appointment for him. So he's going to be seen at the jail as soon as they can get in to see him. Then he'll be released. But the statute allows that, so that's why I took that action.
Is Tara Adams completely off today? Marsha called me earlier, but I must be confused.
No, I got it also, man. He's MIA.
Well, no, it's not off. We're going to go ahead and call that. Thank you for bringing that up. Yeah. I'm looking here. I just found my docket. So, and she is on the docket. So we'll go ahead and call that one. So thanks for not letting me get off too quickly. All right. Case number 21CR117. You good to go there, Ben?
Yes, sir.
Okay. 21CR117, Stablehire versus Tara L. Adams. Appearing on behalf of the defendant, this hearing is being conducted by Zoom. Appearing from the jail room is Attorney Jacob Wagner, and representing the state is Prosecuting Attorney Collins. The defendant has not appeared. She has entered a plea of guilty, I believe, to possession of heroin, a 4th-degree felony, and the matter was set for a hearing this morning. Originally, I think, was set in the afternoon. It was moved back on October 21st to today at 11 a.m., and she was notified of that. She is not present. I'm sorry, it was set originally at 1 p.m., and it was changed to 11 on October 21st. Yeah, very quickly. All right. So, Ms. Adams has not appeared. However, I've been informed by the reading the pre-sentence report that she has not reported to probation for a pre-sentence interview. Also, she had left the counseling center, detox center, without permission, stating she needed a vacation. Have you heard anything more from her, Mr. Arajima or Mr. Fulton?
The last time I heard from her was on the 1st. She left me a voicemail, but I haven't been able to reach her, and she hasn't called back since.
Okay. All right, and Mr. Fulton, you've not heard anything more since your attempts to make an appointment for her?
No, Your Honor.
Okay. All right, well, the court will issue a capias for her arrest. However, if she should happen to come or log in at 1 o'clock, I know you're not available, Mr. Wagner. If that should happen, we'll tell her to report to probation, and we'll set another date. I'm not going to hold my breath, but in the event that happens, that's what we'll do.
If she pops in, Your Honor, have Ben text me, I'll shuffle or stop on.
Okay. Well, you're not going to be available this afternoon, are you?
I don't anticipate her. If so, I'll pull myself away if I have to.
Okay. I know it's too cold to play golf, so.
I don't golf anymore, Judge.
Yeah, but did you golf any less, as Connie Kern would say?
I'm not going.
All right, I think that's it then. All right, for this morning, I'll see you. See the 1 o'clock. Let's see. Wait a minute. 1 o'clock, Miss Collins. We went ahead and continued that one. So it'll be 1:30, Mr. Howard, which we converted to a pre-trial, and then 2:30. There's a little